Good evening from New York. I'm Chris Hayes. We've got some breaking news just now on the central economic policy of this Trump administration. In a huge blow to the White House and its agenda, and a big win, I would say, for everyone else, a federal appeals court has just ruled that Trump's sprawling tariffs are unlawful and invalid. Of course, the president has been obsessed with imposing his willy-nilly tariffs on Americans. In fact, it has been the central plank of his entire economic agenda. Now, it has been wildly unpopular. It's polling underwater. It is costing consumers and corporations billions and billions of dollars by the day. It's stopping the Fed from cutting interest rates by driving inflation. It has, on the whole, been really bad economic policy. And most of the discussion of these tariffs have been focused on that. But there's also something about these tariffs, which is that from the jump, they've been pretty clearly illegal. I mean, think about it for a second. Can the president just by himself create tariffs that raise hundreds of billions of dollars with zero congressional input? These tariffs are a violation of the law that they purport to use as the justification, and a violation of the spirit of the Constitution of a country which was quite literally founded on the belief the executive cannot unilaterally just impose a tax without representation, specifically tariffs. Now, the Trump administration has claimed that its tariff regime and the reciprocal tariffs that it has, and those on China and Mexico and Canada, that those are an emergency measure under a 1974 law, and that made it legal. Well, when this was challenged in a district court, the district court judge said, no way, this does not comport with the law. So the Department of Justice, acting as Trump's lawyers, appealed. And now, just 20 minutes ago, in a huge development, an appellate court has just upheld that ruling 7-4, the federal appellate circuit, saying it is illegal. All the tariffs you're citing are illegal. The emergency you claim is not a valid basis to break the law. Neil Katyal argued this case on behalf of the plaintiffs who just emerged victorious. He previously served as acting Solicitor General of the United States, and he joins me now. Neil, frame the argument that you made and what the court said about those arguments.
Yeah, so I want to begin, Chris, by saying, like you started by saying it's a blow to the President Trump. The way I really think of it is it's a win for the Constitution, and it's always, a very serious, sober thing when you challenge presidential action, and something you have to do really carefully. But when we looked at this, and I'm privileged to represent a number of small businesses, we looked at it and said, look, this just is way beyond the constitutional pale. And that's what the 7 judges today said on our nation's second highest court. They looked at it and said, the president under our Constitution is given no power to impose tariffs. Our founders expressly gave that to the Congress in Article 1, Section 8. And President Trump himself recognized that last time when he was president. He went and asked Congress for the authority to tariff, and they said no. So President Trump this time around just did it on his own. And what we said is you can't do that under the laws and Constitution of the United States. And that's what I'm glad to see the court reaffirm today.
Yeah, I thought this is an interesting phrasing. This is the federal circuit, which is an interesting and unique appellate circuit that deals with certain jurisdictions, including international trade. They talk about the 5 executive orders that impose tariffs and they say unlimited duration on nearly all goods from nearly every country in the world. Which I thought was, when you put it like that, you think to yourself, yeah, that does seem like a pretty broad claim of executive authority.
Yeah, as broad as it could get. And I think this is one thing that the judges were concerned about, and certainly we've been thinking about, which is the Trump administration is saying they want to bring this case to the Supreme Court. And this U.S. Supreme Court for many years has been saying, in particular with respect to a lot of different President Biden's initiatives, these questions are too major for the president alone to decide. They have to be done by the Congress. And here you got something as major as it gets. The Nonpartisan Tax Foundation says that these tariffs are the largest tax increase on Americans since Bill Clinton in 1993. And yet Congress had nothing to do with them. It's just President Trump and the stroke of his pen. And that just can't be the right way to run a constitutional system.
It's been interesting to cover this as we have, because so much is focused on the concrete effects. I mean, right now, if you're buying coffee, for instance, you notice that coffee's gotten very expensive. We don't grow a lot of coffee in the U.S. There's a little bit in Hawaii, but we import a huge amount of coffee. That coffee is being tariffed. So there's all sorts of effects. But the discourse didn't really talk about the legal foundation. The argument that they're making is that there's a 1974 act that allows them to declare an emergency under which they can impose these tariffs. But what's interesting about that act is it doesn't use the word tariff at all. It's entirely about sanctions on essentially countries that we have some geopolitical adversarial relationship with, right?
You're exactly right, Chris. You're doing excellent lawyering. I suspect it's in part due to your spouse, who's an amazing lawyer in her own right. But that's exactly right. The government is saying, in this case, the Trump administration is saying that in 1977, Congress passed a law that gave the president emergency economic powers. And the court today said, yeah, that's true. There's only one problem with that. That 1977 law says nothing whatsoever about tariffs. No president in the 50 years since that law was passed thought it had to do with tariffs. And as I said a moment ago, even Donald Trump didn't think it had to do with tariffs, because the first time around when he was president, he went to Congress to try and get the tariff authority that he's now asserting. And Congress said no. And I suspect, he's worried Congress would say no if he asks again, for all the reasons that you were explaining earlier.
One of the things here, and I want to read again from this decision here, that this is the sort of core of the holding. For the reasons discussed above, we discern no clear congressional authorization by IEEPA, that's the 1977 law for tariffs, of the magnitude of the reciprocal tariffs and the trafficking tariffs. Reading the phrase regulate importation, which is the statutory language they're citing, to include imposing these tariffs is a wafer-thin reed on which to rest such sweeping power. How confident were you about winning this case? I mean, you obviously had the lower court on your side, but also courts have been fairly deferential to presidential declarations of emergency powers.
Yeah, no, when you're challenging presidential action, if you're the president facing these challenges, you almost have to try to lose the case. It's like failing kindergarten. You got to try. But I think that's unfortunately where we were here. And that's why, I'm privileged not just to represent this myself, but with a whole group of very conservative folks. The Liberty Justice Center is the entity behind this, a libertarian organization. Judge Michael McConnell, a very prominent former judge, very conservative. It's not, this is, when you get to something like this, Chris, the Constitution is not political. It's a bipartisan document that speaks to all of us, and it sets certain ground rules. And one of those ground rules was enforced today. The idea that the president on his own can't tax the American people. That's what King George III tried to do. We had a revolution about that.
Yeah, final question for you. I think this is probably, we're not at the Supreme Court yet, but probably the most significant ruling in restraining assertions of power from this president since what happened with Kilmar-Abrego Garcia, which did go up to the Supreme Court. The big question is, how confident are you? The Supreme Court's almost certainly going to take this up. How confident are you there?
So I'm very confident in the merits of our argument, Chris. I think it is, rock solid, extremely strong. And I know that there's sometimes some in the public who say, well, this is a court that's dominated by Republican appointees and the like, and you can never get a, liberal victory or something. And I have two things to say that. Number one, this isn't a liberal victory. This is a victory for the rule of law that conservatives and liberals should celebrate alike. And number two, the court has shown time and again that it can reach conclusions that are at odds with conservative ideology when the law says so. And, when I argued Moore versus Harper, and we talked about that a couple of years ago, is a good example. So I think let's let, the process play out. Our hope is that the administration doesn't appeal this, that they go to Congress and ask for the authority that the court says. That's what the Constitution says they should be doing. But if they do decide to appeal it, we will be ready at the U.S. Supreme Court for them.
Stephen Miller just posting on social media, the judicial coup is out of control. Those are his words, presumably in response to this. Neil, thank you so much. This was a last second coming to join us in this breaking news. I really, really do appreciate it. Have a great weekend.